Good afternoon. This is Judge Lopez. Today is April 9th. I'm going to call Ultinon. I'll take appearances at the virtual hearing, so I will turn on my camera, and if parties wish to hit 5-star, I will unmute your line. A 312 number.
Good afternoon, Your Honor. Brian Lowe and Clifford Chance, proposed counsel for the debtors.
Okay, good afternoon. A 302 number.
Good afternoon, Your Honor. Matthew Sonnet DLA Piper on behalf of Ultinon Motion Holding B.V.
Okay, a 212 number.
Good afternoon, Your Honor. Christian Jensen, Sullivan Cromwell on behalf of Banco Santander.
Good afternoon. Okay. Okay, just give me one moment and we'll get started. Okay, I'll turn it over to the move-in.
Thank you, Your Honor. Again, Matthew Sonnet DLA Piper on behalf of Ultinon. Your Honor, thank you. Let me start out by saying thank you to Your Honor and your staff for accommodating us on an emergency basis today. We filed a motion at docket number 91 seeking limited relief from the automatic stay so that Ultinon may take a procedural ministerial step in the Netherlands to prevent the lapse of its prejudgment attachment on certain accounts at Citibank in the Netherlands from expiring or lapsing it by operation of law. Your Honor, at the outset, we filed earlier today a declaration from my colleague, Mr. James Menker, pursuant to Federal Rule of Civil Procedure 44.1, attaching a memorandum of law from our colleagues at Field Fisher in the Netherlands to provide Your Honor with certain excerpts of Dutch law and their applicability to the relief we've requested today. So, Your Honor, I think whether or not Your Honor grants modification of the stay comes down to whether the debtor should be permitted to utilize the automatic stay as a sword here rather as a shield. Certain facts are not in dispute. The debtors acknowledge and have stated in their first day declaration and elsewhere that pre-petition Ultinon obtained a leave from a Dutch court and obtained a prejudgment attachment of certain accounts at Citibank in the Netherlands. And Your Honor, I'll say the debtor referring to the Dutch entity as opposed to the other debtors in this case, which are not exactly related to that action. So, Your Honor, I think first perhaps it makes sense to seek to move the admission of Mr. Menker's declaration filed at docket number 98. I communicated this to the debtors and we spoke beforehand. We don't intend to call a witness today, Your Honor, but I think it makes good sense to move that into evidence first.
Is there any objection?
Your Honor, for the record, Brian Lowe on behalf of the proposed counsel for the debtors. Mr. Sandman did and I did speak. I certainly don't have any objection to admitting the declaration and the English translation. We received the declaration a couple hours ago. There are some paragraphs in the declaration that I think may go beyond translation of Dutch law and may offer opinion or potentially expert testimony. I noticed that the individual that signed the memo is in the courtroom. Otherwise, I think this would be hearsay. So we just haven't had a chance to look at the numbered paragraphs in great detail. So to the extent that Your Honor is going to take that into consideration for the truth of the matter asserted, I may want a second or two to review those a little bit more carefully.
I'll give you as much time as you need.
And Your Honor, Mr. Lohan is correct. The signatory to that memorandum of law, Mr. Willem, is on the line with us today. He's advised that he would agree to testify as needed, However, I don't think there's actually much of a dispute as to Dutch law. I believe the paragraphs my colleague for the debtors is probably referring to takes the law and applies it to the timing issue at hand here.
Which paragraph are you focused on, Mr. Lone?
If you look, well, frankly, Your Honor, we haven't had a chance to really dig into all the paragraphs, but
No.
if you look at the exhibit,
Yep.
if you look at the exhibit, there are relevant provisions of Dutch law in Dutch and in English, a translation. No problem with those. Above those paragraphs seem to be a statement as to the applicability of or interpretation of the law.
Kind of the construction of the
Again,
law itself. So you're fine with the I see.
Yeah, and to go back to Mr. Sandler's point, Your Honor, I don't know that. I know there's been a lot of paper push back and forth on Dutch law. I don't know at the end of the day how relevant it is to this court's decision. So, and given the declarant is in the courtroom, I think my hearsay objection is going to be overruled. I would just ask that if we get into the substance of those paragraphs, that we take a second and allow me to dig into the substance.
No, I think that's fine. That makes sense to me.
Thank you, Your Honor.
All right, so we'll admit it subject to cross then.
Thank you, Your Honor. And again, going back to that, I don't think there's actually a disagreement of the Dutch law here, and so I'll walk through kind of an overview of why we're here today on an emergency basis, which is a direct result of that law. So, Your Honor, on March 20th, my client initiated action to obtain a prejudgment attachment on those accounts in the Netherlands. By application of Dutch law, that starts a 21-day clock for Lumelids to serve what's called a writ of summons on the Dutch debtor. That expires tomorrow at the end of the day. Without serving that writ of summons, the attachment lapses by operation of law. And so as I understand it, the writ of summons is a simple document that provides a docket date, which my client is advised will set for April 2027. In between now and that date, there will be no material action from Lumelids. There will be no need for material action from the debtors, no court intervention or action. That simply will set the timeline. And we've proposed it as April 2027 to avoid any contention that something might happen before what I understand to be a quick Chapter 11 case where the debtors are moving expeditiously toward a plan and confirmation.
You said, can you, two questions. What is the, and parties can disagree, but what is your understanding of the legal effect of a writ of summons?
Your Honor, my understanding of the legal effect is simply to preserve the prejudgment attachment and then set a date where claims will be filed. Usually, as I understand in practice in the Netherlands, you file something the day before the docket date, setting forth your claims against the counterparty. So, as I would understand, there's no other legal effect in terms of deprivation of any rights, claims, interests, defenses for either my client Lumelids or for the debtor.
And so if I modify the stay, what is your understanding of what happened legally? Then someone would file something in the Netherlands and sets an April 27th date, and then what happens on April 27th?
And to be clear, Your Honor, April of 2027, so a full year from now.
April of 2027. That's different than April 27. Got it. You're saying you're going to put this far out. You're going to put this far out in advance so that this is not an issue, not a date. You're just kicking this out for. Got it. Thank you. That's the claim.
Exactly, Your Honor.
That changed. Okay. Got it. Got it. So you're saying you just want to preserve the right here, go file something, push it, put it at a date far out and see, and everybody, and then the case will have whatever rights, but everybody's rights are preserved.
Exactly, Your Honor. My client just wants to preserve the status quo and not, by operation of law, lose out on its prejudgment attachment which has that 21-day deadline.
Okay.
And so, Your Honor, looking at the xenon anesthesia factors that this court usually looks at in terms of whether or not there's cause to modify the stay, we identified a couple in our papers. The debtors responded with some pushback. So first and foremost, I don't think that there's any interference with these Chapter 11 cases. Preserving the status quo does not remove any rights the debtor has to either, I know it put it in its papers, this potentially, without saying anything, this potentially could be a preference. They have the right, that right's reserved. They can file a preference action tomorrow if they would like. There's no diminution in value because this prejudgment attachment happened pre-petition. The debtor did not have access to this $600,000 and change pre-petition by virtue of this prejudgment attachment. I don't believe there's prejudice to creditors, Your Honor, because they are in the same boat tomorrow, if Your Honor grants this motion, as they are today, and their rights are reserved as well. In terms of two factors raised in the debtor's response, readiness for trial, I think this might be a different conversation if this was an act to collect on a debt or even to liquidate our claims. This is just to preserve our prejudgment attachment and kick the can down the road a year from now, if that's even relevant then. And then finally, Your Honor, the debtors respond with the creation of a judicial lien that might be avoidable. As I understand it, Your Honor, my client has a judicial lien. I think whether or not that's avoidable is the subject of a potential adversary proceeding, which would entitle my client to due process defenses. I'm not sure if that factor is relevant today, as it might just amount to what would be an advisory opinion if this court were to rule that that was the preference when it's not actually before the court today. So, Your Honor, I think under the circumstances, this is a procedural step, it's a ministerial act under Dutch law to keep the parties where they are, to potentially set a platform for the parties to negotiate a global resolution without the clock ticking and without my client losing its rights under Dutch law just simply by the passage of time. So if Your Honor has any questions, of course, otherwise I would defer to my friends on the other side.
Okay, no questions. Thank you.
Thank you, Your Honor.
All right, who wishes to speak next?
Good afternoon, Your Honor. Again, for the record, Brian Lowen, Clifford Chance, proposed counsel to the debtors. We also would like to thank you for hearing this on an expedited basis and accommodating LumaLed's motion, and we appreciate you and your court staff's cooperation on this. This is an important issue for the debtors, as it involves $600,000 of the debtors' cash, which is a meaningful amount given these debtors' estates and the stated goals of these cases. As Mr. Feldman explained at the first day hearing, these cases are simple and straightforward. They're meant to preserve the debtors' assets, primarily consisting of claims and causes of action for the benefit of all creditors, and to transfer those assets into a litigation trust for the claims to be monetized in the future. Our goal was to make this one of your easier cases, Your Honor, and we still hope to achieve that goal. As Mr. Feldman also explained to the court at the first day hearing, the debtors had hoped to file these cases with a fully baked plan, disclosure statement, and litigation trust agreement. However, the debtors' timeline for filing was moved up because LumaLed had, on an ex parte basis, sought to freeze the debtors' cash. The debtors learned of this as they were moving cash into a B of A account. And just for Your Honor's benefit, I'm sure you know this, but B of A is a U.S. trustee authorized depositor, and Citibank is not. And the transfer from the Dutch account was rejected because Citibank had a freeze on the debtor's account. And I want to note that the cash is just frozen. No possession or control transferred to LumaLed's. And, as I mentioned, this covered $600,000 of debtors' cash, and I believe the debtors entered with about $3.4 million as of the petition date. Debtors were and are keenly focused on maintaining the status quo, including by maximizing assets available for pro-rata distribution to its creditors. And thus, after we learned the cash was frozen, the debtors immediately pivoted to filing these cases to prevent any further action from being taken by LumaLed's or any other creditor for that matter. And in our response, we highlight that our pre-petition secured lenders, Mr. Jensen represents, have a pledge over that same account. But for whatever reason, that was never perfected, and actions were not taken by the debtors to remedy that for the very reasons I just mentioned. That brings us now to Lumaled's motion. And I mentioned to you a little bit earlier, Your Honor, despite references to Dutch law, I think the issue before the court is pretty simple and straightforward. And I like to frame this as to what this is and what this is not. And what this is not, Lumaled is not seeking to take a mere procedural step. This is also not an effort by the debtors to deprive Lumaled of its underlying claim once the amount is agreed upon. In fact, Your Honor, I would represent to the court that if Lumaled wanted to have its claim adjudicated in the bankruptcy court on an expedited basis, I'm sure we could take steps to figure that out, and we would be amenable to that. But what this is Lumaled taking a substantive step, not just a procedural one, to post-petition initiate a claim against the debtors to obtain a preferential advantage over the debtors' other creditors, including Mr. Jensen's clients. So in other words, this is exactly the reason for the automatic stay. And perhaps most important, and I will raise this again in a few moments, if the debtors were to file bankruptcy in the Netherlands, the freeze would go away and the debtors' assets would be available for distribution to all unsecured creditors, which is exactly the result the debtors seek in these Chapter 11 cases. So who is Lumaled? Lumaled is an unsecured creditor. It is a party to a pre-petition contract, and according to Lumaled, it has claims relating to the pre-petition breaches under that contract. But Lumaled is not a secured creditor. No security interest was granted to Lumaled under the pre-petition contract, and it's not a secured creditor. Let's talk about the Dutch process in question. My understanding, and I'm not an expert on Dutch law, but in reading papers over the last 48 hours, including Lumaled's motion, my understanding is there are 3 steps. Step 1, ask the Dutch court on an ex parte basis to freeze assets. And by the way, these steps are taken by unsecured creditors. Secured creditors, my understanding, has their own steps to take for remedies that do not include these steps. Step 2, then Lumaled has to initiate a claim on the merits, and finally, step 3, it has to obtain a judgment on the merits. And all 3 steps are necessary to obtain an enforceable judgment. Step 1 happens 6 days before filing, and as a result, the debtor's cash was frozen in one of its bank accounts. And again, the cash is not in possession of Lumaled's, nor is it under Lumaled's control. But step 1 is not enough. Lumaled's needs step 2 and step 3, neither of which happened pre-petition, but both of which are required. And that's why they're here today. Lumaled's is seeking this court's blessing to take step 2, because the automatic stay prevents them from doing so, and thus Lumaled's is attempting to turn its unsecured claim into effectively a judgment lien. And that's the purpose of the automatic stay. It is preventative and disruptive in nature. If a creditor is granted a security interest, which we don't have here, but fails to perfect prior to the debtor filing, the automatic stay prevents that creditor from taking actions which could have been taken pre-petition. Filing a UCC is easy, but the automatic stay prevents a creditor from running into this court and saying, let me just take the procedural step of hitting a button and filing this UCC document with the Secretary of State to perfect my lien that was unperfected on the petition date. And similarly, and perhaps more analogous, if an unsecured creditor wants to obtain a judgment lien, it must initiate a proceeding, obtain a judgment, levy or attach that judgment pursuant to the state law or rules of the court. And if a debtor files bankruptcy before that creditor gets to a judgment or attaches the judgment, the very purpose of the automatic stay is to stop the creditor's efforts in its tracks and not allow any further steps, no matter how substantive or procedural they are. Now, turning to the substance of our response, and before addressing why cause does not exist, I want to quickly address the motions, Lumaled's motion's brief discussion of 362B3.
So, Mr. Lemon, let me just kind of just make sure, just from your understanding. So, step 1 has already kind of occurred, right? They got an ex parte order, and I think we all agree it expires in 3 weeks. At least and it expires tomorrow, if you will. Or maybe it's on April 10th is the more accurate phrase. And so your understanding of what they want is to now go do step 2, which is kind of file this, which preserves their right to the prejudgment attachment, right? And then step 3 is they're going to have to go file a litigation claim, right?
Correct.
Essentially kind of
Well,
litigate the claim to a judgment, I should say, and then kind of get a judgment.
Correct. Step 3 is actually getting to a decision on the merits of the claim. Step 2 is filing the claim.
So here's the question I've got is, let's, under Dutch law, let's say step 3 happens, right? What's the effect of the prejudgment attachment at that point? Is it just to segregate the funds, or is it really granting a lien on the funds, or does someone then have to take the additional step? In other words, is it more akin to permanent injunction relief, pending resolution, or is it more akin to a preservation of assets so they don't go anywhere until a lawsuit gets resolved? And
so, Your Honor, I just want to make sure I understand your question. Are you talking about the interim between step 2 and step 3? Or are you talking about after a judgment has been?
Really, to be fair to you, I'm kind of thinking about both, right? At some point, the merits are going to have to be adjudicated as to the amount of a claim, and let's just, whatever the claim number is, right? What is the effect of, if step 2 goes into effect, what then happens? Do they have a lien if there's a judgment, or do they not have a lien, or is there a step after that? In other words, is the effect of what's happening segregation of funds so they can't be used, or is it really kind of, as we think American terms, you can look to this collateral to satisfy your judgment, to the kind of with priority over others?
Yes. So to my understanding, at least between step 2 and step 3, is that the property is basically segregated and frozen. So it can't be dissipated by the company. It can't be transferred. It can't be moved. It's there. Now, I believe, and I just want to go back to, because I did file also a declaration that attached, and I probably should have mentioned this at the beginning of my presentation, Your Honor, I apologize, but at docket number 95, I did file a declaration which attached excerpts from the Code of Civil Procedure from the Netherlands Commercial Court website with a link to the website, as well as a couple select provisions with both Dutch and English. I only was able to read the right-hand column, the English side. I don't know if others can read. But I'm trying to find the provision that I think is responsive to your question. If you just give me 1 second. The 7,701 to 3. So I found page 14 of 18.
Which docket number are you looking at here? Are you at docket 99?
95-1, Your Honor.
95-1. Okay, let me just get there. Okay. Okay. What do you want me to look?
So if you look at page 14 of 18.
Okay.
Article 703.
Okay.
It looks like section 1. It says, where the attaching party has obtained an execution title and the main action that is eligible for enforcement, the prejudgment attachment converts into an executory attachment, provided the title has been served on the attachee attachee, and where the attachment was made in the respect of a third party on the third party attachee. So I think, Your Honor, and again, this is interpreting an English translation of Dutch law. I think a step has to be taken before they have the lien, where they have to obtain an execution title in order to be eligible for enforcement on what's essentially the freezing and segregation of assets.
Okay. All right. What else do you wish to tell me?
Sorry?
Is there anything else you wish to tell me? Sorry, that was my question. I didn't want to. I asked you a question kind of mid-presentation. I just wanted you to go back to what else you wish to tell me. I apologize. I interrupted you, and I wanted you to kind of get back and make sure that you had the opportunity to present to the court.
Well, thank you, Your Honor. And I'll just turn briefly to our response. And before addressing why cause does not exist, I want to quickly address Lumaled's motion brief discussion on 362b3.
Mm-hmm.
Debtor's position is 362b3 exemption does not apply here. First, the debtors maintain there is no interest granted to which post-petition perfection relates to, and any actions post-petition are creating new rights by filing a new claim. In our response, we note that Lumaled is effectively relying on the relation back exemption, which this court is probably most familiar with in the context of perfection of mechanics liens under the various state laws. And not surprising, 2 of the 3 cases cited by Lumaled involve mechanics liens. We also note that the relation back exemption is to be narrowly construed, and its purpose is to protect, in spite of the surprise intervention of the bankruptcy petition, those whom state law protects. And that's quoting the Second Circuit case that we cited in our response. Lumaled does not, nor can it, point to any applicable law that affords it the same special protection that, for example, mechanics liens claimant has under express state statute. Lumaled's argument is based on the fact that it must do something, that it could have done pre-petition, but the automatic stay is now preventing it from taking action. It is not arguing that it has a special right to take that action, notwithstanding the imposition of the automatic stay. And as I previously mentioned, I think this is important. I think there's two main elements I think are very important in this presentation. This is one of them, and the other is the preference I'm going to come to. As I previously mentioned, Dutch law would not protect Lumaled, as the effect of a bankruptcy order in the Netherlands would be to terminate all judicial enforcement and a cancellation of all attachments, which is exactly the effect the denial of the motion will have. Thus, this completely undercuts any suggestion that 362b3 applies, and frankly, it also goes to cause, Your Honor, as well. And support for that is in Exhibit 2 of my declaration. It's Article 33BA of the Code of Civil Procedure. So that leaves us with whether this court should lift the automatic stay for cause. And the debtors believe this is a clear situation where no cause exists, and the creditor should not be able to take any action to prefer itself to the detriment of the other state creditors. Lumaled correctly cites the 12 C-non factors and accurately notes that the factors are not necessarily assigned equal weight, and only relevant factors need to be considered. But notably, despite a fact-intensive inquiry, Lumaled supports its position for cause based on self-serving conclusory statements rather than facts. Several factors are relevant and guide this court to deny the motion. The debtors believe the key relevant factor here is Factor 9, whether movement success would result in a judicial lien avoidable by the debtor. And this is in the Z-non factors that go into consideration for cause. This factor makes this issue simple and straightforward for the court. The debtors don't believe any interest was created pre-petition. Lumaled disputes that. The court does not need to decide this issue. It is, in large part, irrelevant, because if the stay is lifted, any action taken, even if the effect of which is to perfect an interest obtained 6 days prior to the petition date, again, which the debtors dispute, the result is an avoidable preference, and it is the key relevant Z-non factor. And that makes sense, Your Honor, as the automatic stay exists to prevent this very situation. And moreover, as we note, this is not a situation where proceedings have progressed and are ready for trial. It's the opposite. Lumaled is seeking to take the first step in filing its claim. In terms of judicial economy and impact on the impact of the stay, undoubtedly, Lumaled will say that it is impacted by not lifting the stay. Every creditor that has stayed in the middle of taking an action against the debtor will say the same. But as I mentioned, The stay is protective, preventative, and disruptive, and that's its purpose. On the other side, the debtor's estate and the other creditors, including Mr. Jensen's creditors that lent the estate more than $100 million, would be harmed by allowing one pre-petition unsecured creditor to temporarily better position itself at the expense of the estate. The consequence will result in the debtors expending time and resources to avoid Lumolet's preference and delay the ultimate disposition of the cases. Your Honor, the debtors believe Lumolet's efforts to obtain this preferential treatment of the debtors' other creditors must be denied for the following 4 reasons. 1, no exception to the automatic stay exists to permit it to bring its claim. 2, cause generally does not exist to modify the automatic stay to allow it to do so. 3, any interest that the Lumolets may obtain if the motion is granted is an avoidable preference. And finally, Your Honor, denial of the motion will preserve the status quo as it exists today from the debtor's perspective, where unsecured creditors, including Lumolets, will share pro rata in the distribution of the debtor's assets. One last thing I would like to directly address to the court. It has not been raised or alleged. I've touched on this several times throughout my presentation, but the debtor's decision to file these Chapter 11 cases were exactly for the reasons stated in the first day declaration and by Mr. Feldman at the first day hearing. This was not an end run around Dutch law. In fact, as I've mentioned several times, it would have filed for, if we would have filed for bankruptcy in the Netherlands, Lumolets would be in the same position as it would be if you denied a motion. So we are using the automatic stay neither as a sword or a shield. We are taking advantage of the U.S. Bankruptcy Code as we're permitted to do and is appropriate in the situation. Unless Your Honor has any questions, I see the podium.
Okay. I'm going to note there was a Chapter 11 case filed by Ultinon on March 26th of 2026. Shortly thereafter, the court granted certain first day relief. We're still at the kind of what I would consider the infancy of this Chapter 11 case. On April 7th, there was an emergency motion requesting relief from the automatic stay to serve a writ of summons in accordance with Dutch law. The relief requested included emergency consideration of the motion because on April the 10th, there's a lapse of a prejudgment attachment as described in the motion and by the parties today under Dutch law. So the court granted emergency consideration of the motion on 2 days' notice because these are obviously an important issue for the movant here. The court has considered the evidence, and so I'll note I'm going to grant emergency consideration of the motion. I think the April 10th date was important, and it was important to get a ruling from the court and not simply, if you will, allow this to lapse in effect without having an opportunity to be heard. The court has in the record a declaration from a Dutch counsel law firm of summarizing and translating applicable Dutch law on this issue. And what is clear are a few things. One, that kind of before this case filed on March 20th, which was about 6 days before this case filed, the Dutch court granted Lumolets leave to levy a prejudgment attachment against one of the debtor's bank accounts, city bank accounts in the Netherlands. Prejudgment attachment was affected under Dutch law, and kind of the notification contained an order to Citibank to retain these assets. So these assets are effectively frozen in a bank account, in a Citibank account. And in March, the debtor filed for bankruptcy a few days later. I would note that the first day declaration did kind of identify these issues. So, but today we're here. Under Dutch law, the parties agree that third parties, an attachment lapses automatically by operation of law unless, the party initiates a claim in the main action within a prescribed period of time. It's a statutory prescription, and that expires tomorrow. And there would have to be a writ of summons, has to specify a certain docket date. Mr. Sarna has indicated, and then they would put it well far out in advance, so there wouldn't be any issue here. So Citibank was notified of the prejudgment attachment on March 20th, so the 3-week period expires on April 10th, unless there's this procedural step of initiating claims in the main action. So this kind of, one is kind of how debtor obviously objects and says the automatic stay should not be lifted. If there's two arguments raised by Luminance. One is that this is just kind of this is accepted from under 362, kind of B3. It's just a continuation of perfection. I will tell you, I gave everyone an opportunity to testify. It's not entirely clear under Dutch law what this prejudgment attachment operates more as like a freeze order, kind of freezing the assets there until a judgment can be rendered, so kind of allowing someone to kind of have the money frozen in a certain account. And 362b3 really talks about taking steps to perfect a lien, and so that applies with mechanics liens and statutory liens, where by a certain date you may have a statutory lien, but that lien requires additional paperwork to file it with the Secretary of State to perfect that lien. This is different. This isn't, and I'm not convinced that based upon the presentation under me, it's clear that under Dutch law, this act of filing that Luminance wants to do is essentially going to perfect anything. And so 362b3, this is the automatic stay is in effect on this, and the question is, should it be lifted? The parties are correct that the bankruptcy code provides that the stay can be lifted for cause, and cause is the fact and of circumstance, depends on the facts and circumstances of each case. Courts have considered a number of factors in connection with matters, bankruptcy courts, but again, it's fact intensive. Not every factor applies in every case. You've got to kind of consider the facts on the ground and make an assessment as to whether cause is there. But courts do, sometimes there's litigation in cases, sometimes there are acts that happen pre-petition, and sometimes, you kind of have the melting ice cube. It really depends on the facts and circumstances of every case. In this case, really what's being asked of the court is to kind of allow Luminance to kind of continue having those funds frozen in that account until there can be a judgment and a merits, and that could happen sometime in 2027, if you will, maybe earlier, and what court would decide that, whether it be this court or a Dutch court, and is an unknown question. Whether this would create a lien ultimately, and whether that lien could be avoided. It's not entirely clear to me that this would qualify even as a judicial lien, because a lien secures payment, and it's unclear that even under one could certainly have assets available from which to collect, but in a plan in which there was a ratable distribution of assets to similarly situated creditors, I don't, it doesn't secure a right to payment. So it's questionable whether there's a lien, and I'm looking at the definition of lien under Section 101 and whether that would require a preference action to resolve. I do think the relief requested is really just to freeze the money, as I can tell, at best under Dutch law. And again, the court is just presenting based upon the translations that have been provided to this court, and make no assessment, final assessment as to whether that's, I think. I'm going to deny the relief requested, but I don't think there's cause to lift the automatic stay. I think I have multiple, from what I can tell, multiple unsecured creditors in connection with this case, and a plan would require use of those funds, and there's still going to have to be litigation to determine these issues. And I certainly think Lumilands at the appropriate time would be able to continue its litigation and proceed in the appropriate court to go liquidate its claim. That being said, I think the right answer for today is to tell the debtor that I don't want any money moving today without me knowing where it's going. I don't want those funds to dissipate. As a matter of fact, I think if this is going to be a fast Chapter 11 plan, then, which is what everybody's telling me, I don't know if it is or it isn't, but I think the right answer is the money stays right where it is. The money doesn't move into another account. The money stays there. This account, this prejudgment attachment may lapse, but I still think parties have the right to make sure that there'd be something there in the event. And it seems to me that Mr. Jensen and Mr. Sarna and Mr. Lowen and others can come together and figure out what's the best course of action. I think protracted litigation on all these issues seems like it's going to get very expensive, and no one's really going to benefit aside from professionals on this. And I think it's in the best interest of the estate for parties to just take a day, get in a room, and figure all this out, if that's what it takes. But Mr. Sarna, I think I'm going to give you the functional equivalent of what you may be looking for. Is that maybe the debtor can convince me that it needs money to go do X, Y, and Z, and parties will be able to look to that. But today won't be that day. Today will just be the day where everything kind of stays status quo. Parties will get back to work, but I don't see this as a lien issue, a security interest issue even under Dutch law. I think we're still preserving status quo, and I think I get really comfortable that seems like under Dutch law this would have gone away anyway, but this you filed in the United States, so I'm not sure that that's really relevant to me one way or the other. But what I do think is just preserving everyone's rights so that this case can proceed, and parties who are getting notice in a foreign jurisdiction kind of have some comfort that the court is taking everything one step at a time and looking at everything one step at a time. So I'm going to encourage the parties to kind of, I don't know. There's this estate just really could just use some good old conversations to figure out the best way to proceed. And it seems that that's exactly what debtors counsel wants to do. And I just strongly encourage creditors to see if they can start talking. Anyway, that's my ruling. But yes, Mr. Lowen.
I just wanted to assure the court that I take your words of encouragement to heart. It is the intentions of the debtors and the debtors professionals to move forward quickly and expeditiously. I meant what I said at the top of my presentation.
Oh, I know you did. And I want everyone to hear it. And that's the way I'm thinking about it. And so that's why I'm kind of ruling the way that I'm ruling, but still kind of making sure that stuff isn't going to move from one place or the other and all of a sudden everything is gone. Just let's keep everything where it is for now, and we'll see where it goes. And I understand that may require 345B extensions or whatever whatever they need, and we'll get there. So I thank everyone for their time. Thank you.